Good morning. This is your Kelso Report for Tuesday, March 20th, and I'm your host, Clark Kelso. Today we have the Ninth Circuit granting an in-bank in an interesting search and seizure case. We have a death penalty decision from the California Supreme Court, juvenile law, and criminal law. Let's get started with the Ninth Circuit, which has granted in-bank review in a case United States versus Cotterman. Now, almost a year ago, in United States versus Cotterman, a split panel of the Ninth Circuit held that a search of a laptop computer that began at the border and then ended 2 days later in a government forensic computer lab 170 miles away still fell within the scope of the border search doctrine. According to the majority, which consisted of Judges Tallman and Rawlinson, quote, "We find no basis under the law to distinguish the border search power merely because logic and practicality may require some property presented for entry and not yet admitted or released from the sovereign's control to be transported to a secondary site for adequate inspection," close quote. Instead, the majority found that the duration and circumstances of the search were not so egregious as to render it unreasonable. Judge Betty Fletcher dissented. For Judge Fletcher, the case was not about the 2-day delay or where the search occurred. Instead, she dissented on the ground that the government seized the laptop without any particularized suspicion whatsoever in order to conduct an exhaustive forensic search of its contents. It was, in Judge Fletcher's words, quote, "the type of generalized fishing expedition that the Fourth Amendment is designed to prevent," close quote. Well, yesterday, a majority of the Ninth Circuit voted to take this case in bank. I have to say that I think I lean more to the dissent than the majority in this case. The search that was conducted certainly doesn't sound like the type of search you'd expect as a border search, absent any particularized suspicion whatsoever. We'll see what the in-bank panel does. Next, we have a death penalty decision from the Supreme Court of California, and of course there's no surprise here, there's an affirmance. The defendant was convicted of first-degree murder, with the jury also finding he had personally used a firearm in the commission of the offense, and finding true the special circumstance that the defendant had committed the murder during the course of a robbery. Nothing so special about that. The court imposed a sentence of death in United States versus Abel. It took a unanimous Supreme Court 66 pages of ink to reject the assorted collection of meritless grounds for appeal. Let's turn to California Court of Appeal, an interesting juvenile law case. While a jurisdictional petition was pending under Section 300 of the Welfare and Institutions Code, the mother willfully left the jurisdiction with her children. Well, under the doctrine of disentitlement, the Second District in Los Angeles County Department of Children and Family Services versus GN dismissed the mother's appeal from the juvenile court's final order. The disentitlement doctrine is not jurisdictional, but is instead a discretionary tool to be used as a sanction in limited circumstances. In the criminal context, it can be applied when the appellant is a fugitive from justice. In dependency cases, the doctrine has been applied only in cases of the most egregious conduct by the appellant, conduct that frustrates the purpose of dependency law and makes it impossible to protect the child or act in the child's best interests. Well, the appellate court found that the mother's conduct in this case satisfied that high standard. The case involved allegations that the father had sexually abused one of his daughters, and that the mother had allowed the father to continue to live in the home even after the court had found that the abuse had occurred. After some additional proceedings in the trial court, the mother fled to Mexico with the daughter, apparently at the same time that the father fled to Mexico. The appellate court held that was enough to trigger disentitlement once they returned and tried to appeal the adverse order. Next, criminal law. The defendant was convicted of vehicular manslaughter with gross negligence, based on evidence that he broadsided at high speed another car, resulting in the death of an 8-year-old who was strapped into a booster seat in the back seat of the other car. In People v. Tom, the First District reversed the conviction because the prosecution apparently forgot what it means to have a privilege to remain silent. During trial, the prosecution introduced evidence of the defendant's post-arrest, pre-Miranda silence as proof of guilt. In particular, the prosecution elicited testimony from 2 police officers regarding the defendant's failure after the accident to inquire about the well-being of the occupants of the other vehicle. And the prosecution used that silence as substantive evidence of guilt. Well, as the First District noted, the right to remain silent does not suddenly spring into existence only after a suspect has been given his Miranda warning. Indeed, the whole point of Miranda is that the right to remain silent exists at all times, and the suspect should be reminded of that right before the police begin any interrogation. In this case, the prosecution tried to take advantage of the defendant's silence in violation of the Fifth Amendment. The First District found that use of the defendant's silence was highly prejudicial in this emotionally charged case involving the death of a child, and so it reversed the conviction on those grounds. And that's it for today's Kelso Report. Have a great day in the law.